And Judge Cannon, dismissed the charges unlawfully filed by illegal Jack, not a real boy. 515 does not explicitly empower the acting attorney general to appoint or retain anyone from that case. It requires a clear statement. As we talked about, you can't just make inferences because Congress knows how to talk. It's a role that Jack Smith expressly disclaims. He's not helping another U.S. attorney. He is acting as a U.S. attorney, even though he's not appointed. Jack Smith is back on the ropes for the second time. We already know that Judge Cannon dismissed the classified documents case and said that Jack Smith is not a real boy, not a real prosecutor, was never appointed properly by the president, certainly not confirmed, and so he had no authority to prosecute Trump at all in the classified documents case. Shouldn't have happened, but it did, until Cannon stepped in. Now, the same question, of course, pops up in a different jurisdiction. Why is Jack Smith still prosecuting Trump elsewhere if he's so illegitimate? Well, Trump's team has now emerged, and they've said, now's the time to bring this to your attention, Judge Chutkan, in the January 6th case, because we're still working through the immunity issues, but now it's time to say, Jack needs to go. We don't need to have any of these appendices being dropped. We don't need these last-minute election filings. If Jack Smith is illegitimate from the beginning, from President Trump and his defense, telling us President Trump's proposed motion to dismiss is here, and we want injunctive relief against Jack, not a real boy, because there's a violation of the Appointments Clause. He was illegally appointed, and the Appropriations Clause. He took money that was never belonged to him, never appropriated to him or this prosecution. So here's what Trump's team says. They say President Trump respectfully requests leave to file this proposed motion, right? So they haven't actually filed it yet. They need permission from Chutkan to do it, to dismiss this superseding indictment and for injunctive relief, which is timely, by the way, and supported by good cause based on violations of the Constitution's Appointments and Appropriations Clause. Now, leave should be granted. You should give us permission to file this because in an intervening opinion, while this case was stayed up on appeal with the Supreme Court, in a parallel case, Justice Thomas observed, actually, I think that was in this decision. He was referencing the appeal. They say Justice Thomas observed in a concurring opinion, right? It's not law, but Supreme Court Justice Clarence Thomas. He said in an opinion, Trump versus United States, which I think this was the appeal of this issue, right? Because this was paused for a while it went up on appeal and we determined whether immunity applies. Of course, it does apply. And so it came back down. Now, in a concurring opinion, which is not the holding of the case, Thomas said this. He said, there are serious questions whether the Attorney General has violated our constitutional structure by creating an office of the special counsel that has not been established by law. They made it up. The office came out of nowhere, came out of the Reno regulations, and they cobbled together a bunch of U.S. code statutes that don't even apply. So Thomas is hinting there's a problem here, and they're telling Chutkan that. Now, these issues are jurisdictional, okay? You can't just forfeit them or waive them. In other words, they are necessary for the case to move forward. If you don't have jurisdiction over the case, what are we doing here? Everything has to go away. In another intervening decision, a district court issued a thorough and well-reasoned opinion and relied in part on Justice Thomas's concurrence and credited many of the arguments that were raised by President Trump. And Judge Cannon, dismissed the charges unlawfully filed by illegal Jack, not a real boy. Now, the superseding indictment from Jack, because Jack had to do this over again because he's so terrible at his job, filed after both of these intervening decisions. So Jack Smith got backhanded, and then he's like, let me try again, which warrants a new set of deadlines, by the way. So don't say this is untimely because Jack started the clock over again with his second indictment. Now, that is how the court proceeded in connection with the statutory motion to dismiss, and there is no countervailing reason to deny this motion here. So there's no bar to the proposed motion. You cannot waive this issue. It's a necessary condition. You have to have jurisdiction before you can start releasing appendices, even though she's already done that. Now, the proposed motion establishes that this unjust case from Jack Smith and Kamala Harris was dead on arrival, and it was unconstitutional even before its inception. In November of 2022, you may remember this, Merrick Garland, our Attorney General, violated the Appointments Clause of the Constitution by naming a private citizen called Jack Smith to target President Trump while Trump was campaigning to take back the Oval Office from Biden, which is Merrick Garland's boss. And he did that. He appointed private citizen Smith without any statutory basis to do that. Okay, there's no statute that says you have the power to do this. What did Garland do? Well, he did that following improper public urging by Biden. Biden said he needed to do something, as reported at the time in 2022 and repeated recently by Biden through his inappropriate instruction to, quote, lock him up, which we played here on our channel, while Smith presses forward with this case right as the presidential election rapidly approaches. Now, everything that Jack Smith did since Garland appointed him, as President Trump continued his leading campaign beating Biden, and before they cooed him out, now we've got Harris, everything that Jack did was unlawful and it was unconstitutional. Now, that includes Jack Smith's separate violation of the Appropriations Clause, which is about the money, by relying on an appropriation, which is a slush fund, that does not even apply to him, in order to steal, they say take, I'll say steal, more than $20 million from American taxpayers to use against a presidential candidate. It's government funding of political opposition and lawfare. We're funding it. In addition to Smith, Jack also relying on more than $16 million in additional funds from other unspecified DOJ components. So $36 million that they've absconded. Now, Smith was not appointed by the law, okay? The U.S. Constitution says you have to be appointed. None of the statutes, none of the laws that were cited in order to appoint Jack Smith, none of them provide the type of clear statement from Congress that is necessary to authorize a department head to appoint an inferior officer like Jack. In fact, far from the required clear statement, the plain language of the statutes that they used, as well as the context, the historical understanding, all of those things directly undermine the validity of his appointment. In fact, the statutes show he shouldn't be appointed. At least one Supreme Court justice, a district court called Judge Cannon, two former attorneys general named Ed Meese and others who administered the laws at issue back during this time, several prominent legal scholars, among others, all of us here at Watching the Watchers have supported that conclusion. Now, courts in this district, on the other hand, have erroneously relied on a single sentence from Nixon, which cited the same statutes that Garland used to appoint Smith. Now, the sentence is dictum, not to be confused with the Fannie Willis case. Dictum meaning it's not relevant to the holding, as it lacks reasoning, was based on an undisputed issue that wasn't even part of the case, was not necessary to the Supreme Court's holding, and is not even an accurate characterization of the statutes that are at issue. Now, decisions from this circuit in the D.C. circuit that rely on Nixon did not address intervening decisions regarding the clear statement rule or the major questions doctrine. Now, as such, they do not control the outcome of this motion. They're not persuasive authority. Jack Smith can't rely on that, and he's not lawfully appointed. Now, even if Smith is a valid officer, which he's not, by the way, they're writing, he is a principal rather than an inferior officer, and his appointment is plainly unconstitutional because he was never nominated by the president or confirmed by the Senate. This conclusion follows from the lack of effective oversight over Smith. No one's in charge of him, they kept saying. He's like an independent counsel, and he can do whatever the hell he wants. So he doesn't actually fit into anything. It's almost like they created their own department for Jack, like he's his own U.S. attorney's office. So he had no boss, essentially. He had extremely broad jurisdiction, and unless and until he's removed, his tenure is limitless until his work is concluded. These features of his job violate the Appointments Clause. Somebody with those types of powers has to be properly appointed. That's called checks and balances that are part of our system. Now, Jack Smith's massive expenses, 36 million stolen American tax dollars, also violate the Appropriations Clause. He has operated with a blank check by relying on an inapplicable permanent indefinite appropriation that was enacted back when we actually had an independent counsel statute. We used to have rules for this in 1987, but Smith was not appointed pursuant to that act because that act expired back in 1999. Congress had problems with it, and it was a terrible thing. So no, we're not going to do that again. But they still kept this indefinite appropriation fund, and Jack Smith is stealing money from it to prosecute political opponents in America. It's sick. Now, the appropriation contemplates the possibility of appointment by some, quote, other law. But guess what? No other law authorized Jack. The appropriation to get that money also requires that the prosecutor actually be independent in the very particular and the rigorous sense that attorneys that were appointed under the Independent Counsel Act that created that provision, how they meant it to be independent. But that's not what Jack Smith is doing here. And so Jack should have never been permitted to access these huge sums of money and use this funding to prosecute Trump. And so based on all of this, this entire second draft loser indictment that is trying again should be dismissed. And an injunction against additional spending by Smith, cut off his money, should happen right now to prevent the ongoing irreparable harm and to ensure relief for this Appropriations Clause violation. Let's go. Trump's team continues. Their background begins as follows. They say, all right, listen, Judge Chutkan, we're here on the January 6th case. You've been difficult this entire time, but you've been dealing with an illegal, unlawful prosecutor. Here's the story. On November 18th, just 3 days after Trump announced his candidacy for this historic race, Attorney General Merrick Garland allegedly appointed Smith as a, quote, special counsel, and he's, quote, gonna prosecute federal crimes arising from the investigations that they made up. In the order, Merrick Garland cited these U.S. statutes, and they're all various statutes that don't say anything about appointing a special counsel. In a press statement, Garland touted the appointment. He said, the DOJ has a commitment to independence on Smith's part and accountability for unjustly pursued targets. Now, according to the statements available for the expenditures, look at this. From November 2022 to March 2024, Jack's office has spent $20 million just alone. That's excluding the last 7 months. Then an additional $16 million in DOJ component expenses that are attributable to this investigation. That is so much money. You know how much money that is? To prosecute one man in 2 cases, $36 million to prosecute 2 cases. It's insane. This extraordinary sum of money was spent only on 2 cases, one of which has been dismissed on the grounds that Jack is illegal. That prominent scholars and former federal prosecutors have criticized this as politically motivated and in violation of the DOJ's policies. Now, the court should grant this motion, okay? It's timely. There's good cause. We're not waiving anything here. This motion is going after the superseding indictment, the second draft, which did not exist at the time of the court's previous motion's deadline because they charged him again and they changed the entire document because, of course, there's immunity that the Supreme Court said. And since this court properly permitted Trump to supplement this file, that's what we're doing. Now, Judge Thomas, he instructed that, quote, the essential questions that were raised in our motion must be answered before the prosecution can be proceeding. Now, this was in a concurring opinion, so it's not binding. He just says, in my opinion, we got to figure out, like, is Jack even legitimate? Does he even have power to charge Trump at all? In addition to the timing of the superseding indictment, Jack's second draft, that command from the Supreme Court supports good cause. That's why we're here. Equally important is the fact that along with Justice Thomas's concurrence, Judge Eileen Cannon, in her very thorough and incredible, we read it, intervening decision, present thoughtful and important reasons supporting this argument. These are fatal constitutional defects that they have in their case, and they're causing irreparable harm, and they cannot be waived. In fact, they must be addressed. Jack Smith's actions pursuant to his unlawful appointment based on funds which he should not have even had access to have resulted in the exercise of power that the actor did not lawfully possess. It is tyranny, right? It is a prosecution by an illegitimate government. The proper remedy is the invalidation of the action, which means everything that was done ultra vires outside of the limitations of his power has to go. It has to be dismissed. Now, because Smith's actions are ultra vires, they're outside of his lawful power. He has none. He's simply a private citizen. He has no power. His lack of standing cannot be ignored. The court does not have jurisdiction over a criminal prosecution that's maintained by someone other than an attorney for the United States. He has no power here. And so we have to address this now. Trump's equitable request for an injunction is not governed by the other procedural requirements. So you can't say this is the wrong time for this motion. These are serious problems infecting this case and the grand jury proceedings and the indictment itself. And so based on these considerations, Judge Chutkan, the motion raises constitutional challenges, and these issues may be considered on appeal whether or not they were reviewed upon or ruled upon below. The purpose of all this is to ensure that we do not lose liberty, says Clarence Thomas. And like presidential immunity, the Constitution secures liberty by separating the powers to create and fill offices. This is the problem. The Biden administration created the office of Jack Smith out of thin air and gave him $36 million. They don't have the power to do that. Congress does. Similar to presidential immunity violations, failure to adhere to the requirements of this risks weakening the presidency. Litigating, challenging government conduct risks enfeebling the presidency. We have to keep our checks and balances in line. Now, finally, there is no countervailing reason to deny filing. Unlike when the original motion deadline was set, there's no trial scheduled. And so there's plenty of time to address this. And so we should do that. So do not bar this motion, Judge Chutkan, because we're here and it needs to be addressed before anything else can proceed. Now, to get to the meat and potatoes here, Judge, let's be clear. Jack Smith was not appointed by law. The Appointments Clause of the Constitution requires that by law. It's in quotes. Article 2, Section 2, Clause 2. Look it up, Judge. You'll find it. The Appointments Clause requires that any congressional decision to vest inferior officer appointment power must be made by law. Now, Jack's appointment order cites no law by Congress that grants the Attorney General to appoint someone like Smith, because there isn't one. Consistent with the major questions doctrine and other cases like this, talking about the separation of powers, a clear statement from Congress is required to support an appointment like Jack's. An inference just from a bunch of other statutes that says, well, you have power to do this and power to do that, doesn't count. The Supreme Court has applied this clear statements rule when a statute implicates a historically or constitutionally grounded norms that we would not expect Congress to unsettle lightly. Like if it's kind of a big deal, we need Congress to say something about it. Appointing Jack Smith to prosecute a president with $36 million is kind of a big deal. The Appointments Clause is a safeguard. It's a structural safeguard in our system. Our separation of powers jurisprudence generally focuses on the danger of one branch of government gobbling up and aggrandizing too much power. The Appointments Clause requires that officers be created by statutes with direct congressional authorization. Congress creates it over here, empowers the executive to then enforce it. It reflects the Constitution's original meaning and the framers' balancing of the powers. We don't want the executive branch to create the offices and then prosecute them and do it because they'll create whatever they want, which is what they're doing. This requirement is deeply embedded in the Constitution, and it was central to the formulation of the appointment power. Now, the absence of the legislature's bark is all the more compelling when one considers what the watchdog is guarding. A private citizen like Jack cannot criminally prosecute anyone, let alone a former president, unless duly authorized to do so by the American people. And Jack Smith's appointment order is no everyday exercise of federal power. He unlawfully was named by Merrick Garland. He was a private citizen, brought him out of Europe to investigate and prosecute a former president. It's insane. Garland instructed Smith to investigate Trump's shouldn't have even been prosecuted or investigated at all, his official acts of executive power. And he was charged by that. He was charged with immune official acts. How do we know that? Because he had to do it again. Derp Jack had to file a second indictment. Oops. Oh yeah, let me try that again. Yeah, because you goofed. Shouldn't have done it. Now, exacerbating that constitutional injury in an unprecedented fashion, inconsistent with decades of DOJ practice, Garland did so right when Trump was campaigning against Joe Biden, who held the removal power over Merrick Garland. Now, to put it mildly, these circumstances present unique and sensitive issues for our entire structure of our Constitution. Criminally prosecuting a president for official conduct is a far greater threat of intrusion on the authority of the executive branch than just simply seeking evidence in his possession. See, balancing that. Raiding a president's home is a bigger deal and a bigger intrusion on our government than Trump holding on to documents that were his, and they didn't care because they're just little maniacs who just hate Trump for whatever reason. Well, because he threatens their power and they're power-hungry maniacs. Now, the separation of powers concerns caution against reading legislation absent clear statement to place in executive hands. You don't just give them the power to appoint officers and establish offices like one Jack Smith got. Indeed, there are cases, specifically in the Appointments Clause context, where the Supreme Court has insisted upon textual clarity when there's more ambiguous language. Now, the Circuit Court ruling in this other case, in this sealed case, is not on point. And by the way, that case has been abrogated by more Supreme Court authority. So if you're going to use your precedent to say that Jack is a real boy, well, your precedent is bad. In that case, the court acknowledged that these statutes did not explicitly authorize the appointment of Lawrence Walsh. The panel also correctly pointed out that Nixon had presupposed a valid basis for that case, meaning they didn't actually settle it if it was presupposed. The court nevertheless asserted that the statutes accommodated the appointment. Well, accommodation is not enough where, here, a clear statement is required. Accommodated, that doesn't count. So your precedent is kind of weak. The distinction also addresses a more recent consideration of the appointment of Robert Mueller in 2019. Now, in that decision, the DC Circuit said that the other case was binding, notwithstanding the cases cited above. So they just relied in the Mueller case on the bad case. So they set this really weak precedent, and then they relied on that. As well, we got precedent. These special counsels are perfect because Robert Mueller was going against Trump. So like, yeah, he's great. We love Robert Mueller. And they declined to consider his dispute. And so in that case and in this case, they're not controlling, okay? Because they were decided before the Supreme Court developed this identifiable body of law about this recurring problem, which is corrupt agencies asserting highly consequential power well beyond what Congress could have reasonably understood and ever would have granted. Now, as there is no authority for Jack's unlawful appointment, the case is an instance of the executive seizing the power of the legislature. They created their own office and then filled it. A 1992 case, they said, the Constitution's division of power among the three branches is violated when one branch of government invades the territory of another, which is exactly what Biden did here, whether or not the encroached upon branch approves the encroachment. Now, one of the most vital functions of the federal courts is to police this structure. The court is duty-bound to do so, and you have to dismiss this case, Judge Chutkan. The rules are clear elsewhere. The statutes that were cited in Jack Smith's appointment order contrast sharply with numerous other statutes that do confer the power very straightforwardly. Several provisions of this track the principal officer language of the Appointments Clause. Here's one. Congress has repeatedly demonstrated that it has the ability to imbue the Attorney General with appointment power over officers and employees. For example, Congress authorized the AG to appoint additional officers and employees as he deems necessary. But that statute applies to the Bureau of Prisons, only to the Bureau of Prisons, and there's no corresponding statutory authority for someone like Smith. So they can't apply the Bureau of Prisons powers to the DOJ's power. And further, Congress has at times expressly created offices similar to this position like Jack. So Congress does know how to create this office. In fact, Congress created an office for a special counsel when they were investigating the Teapot Dome scandal, and a statute provided for the appointment of an independent counsel. They addressed that case in Morrison versus Olson. That statute was 28 U.S. Code 592. That's the law, right? Appointment by law. Jack Smith doesn't have one of those. That statute lapsed, and Congress has not reauthorized the appointment of that. So there is no law. Congress knows how to appoint a special counsel or create a law for a special counsel, but they haven't done it for Jack, and they're just using other statutes like the Bureau of Prisons and FBI powers and other things to say that they can make him up. It's not lawful. It's unlawful. These current and former officer appointment statutes, which use specific and explicit language, negate any permissible inference that Congress intended this. So in other words, Congress knows how to speak. They can speak, and they do. So you can't now say, well, they didn't speak here, but we can infer that they intended to speak. No, they know how to speak. They'll open their mouth if they want to. They haven't opened their mouth here. So you don't then get to suddenly say you're legitimate. Therefore, the superseding indictment must be dismissed. Now, none of the statutes that they cited in their appointment order provides a sufficiently clear statement from Congress that authorizes unlawful Jack. This conclusion is supported by the broader context, as well as a murky record about DOJ's use of outside attorneys. Specifically, the appointment of private citizens like Jack Smith, as opposed to already retained federal employees, are much closer to the exception than the rule. Now, against this backdrop, Merrick Garland's reliance on these statutes destabilizes what Congress intended. This is the exact thing that the framers were concerned about with the Appointments Clause. Now, as a result, the constitutional avoidance canon also counsels against the meritless interpretations that are relied upon by them. We're not supposed to rewrite the Constitution to serve your case. For all these reasons, Jack was not appointed by law. Everything he's done is ultra vires, meaning he has no power to do it. And so dismissal is the only appropriate remedy here. And so let's go through these provisions. Trump's defense continues. They say, listen, Judge Chutkan, just to be clear on this, Section 509 and 510 that Jack Smith is relying on, they do not authorize appointments at all. 509 is a general statute. It says that the Attorney General is imbued with all the functions of the department, except in limited instances for ALJs in federal prisons, okay? Doesn't say you get to appoint anybody. Just says you have all functions of this department. Now, Section 510 says it's a general provision allowing the AG to delegate his functions to officers, employees, and agencies. So he doesn't have to do every single thing. He can hire people. Saying the Attorney General's power to delegate duties to an existing officer is not the same. It's delegation. It's not an appointment power. Other case law supports that. And so this is not something that gives him the power to appoint Jack. So next they turn to 515. On its face, 515 does not explicitly empower the acting Attorney General to appoint or retain anyone from that case. It requires a clear statement. As we talked about, you can't just make inferences because Congress knows how to talk. So they next go to 515. They say, all right, well, this one addresses the types of proceedings in which the AG or, quote, any other officer of the DOJ, officer, or any attorney specially appointed by the Attorney General under law, see that means a statute, may participate. The phrase under law means that an attorney's office must have been created by, the law, not by Merrick Garland and Joe Biden and Kamala Harris. Any other interpretation would impermissibly render the phrase surplusage, meaning it's not necessary, and we don't read things that are written out as unnecessary if we can interpret them as being necessary. statutory. Congress put them in there for a reason. And if we read it in a way that it doesn't matter, then we're undermining Congress's intent. So if we interpret it your way, then none of this matters. This is a provision conferring territorial flexibility to the Attorney General. It allows the Attorney General to use DOJ officers and previously appointed special attorneys to litigate on behalf of the United States regardless of residency. But that doesn't provide for appointments. It doesn't say you have the power to go appoint a non-citizen or a private citizen like Jack. They go to Section B. They say this section addresses titles, oaths, and salary. That's all. Each attorney that is retained under authority of the DOJ, meaning you don't get new powers, it's already granted to you, is similar to under law. It's under authority. It's a reference to an external source of appointment authority. This clause, again, is meaningless if they could specifically appoint people. So the lack of appointment authority in that section is further confirmed by the verb tense. Specially appointed and specially retained, those are past participles that modify the word attorney. Although past participles can take past or present tenses, they were used in the past tense in 515 to refer to an attorney who had already been appointed or retained pursuant to another statute. And so it doesn't convey the power to then create it. It's just if they've been appointed, you could use them, but you don't get power to create it. And finally, the so-called Special Attorney Commission is a reference to another role that's provided for elsewhere. Congress moved those provisions to their current location in other statutes when they wrote the rules. The term special attorney has a known meaning. That meaning is assisting U.S. attorneys. So it's assisting, it's not prosecuting. It's a role that Jack Smith expressly disclaims. He's not helping another U.S. attorney. He is acting as a U.S. attorney, even though he's not appointed. Every other U.S. attorney is appointed and confirmed. Jack Smith was not, and he's not assisting them. Next is 533. They say, well, this one authorizes the appointment of FBI officials. Okay, it's FBI, not DOJ. Totally different section of the law. It doesn't authorize private prosecutors like Jack. It's not a clear statement. The appointment order and their meritless citation to the FBI would shoehorn appointment authority for U.S. attorneys, meaning if we could do this statute allows us to hire FBI personnel. So wait a minute, we can then appoint U.S. attorneys by using an FBI hiring statute? What kind of nuts is this? Such an interpretation would render superfluous these other powers, these other things, and you could just insert whatever you wanted in there. So this provision would be a really curious place for Congress to hide the creation of an office for a special counsel in the FBI. Weird. It's placed in a chapter concerning the FBI. It's not even included in the U.S. Attorney section. Chapter 33 and 533 supply clues of congressional intent. So does the FBI website. Under the heading, they say, where is the FBI's authority written down on the FBI's website? FBI.gov FAQ. The FBI says, federal law gives the FBI authority to investigate all federal crime not assigned exclusively to another federal agency. And the Justice Manual says something similar. So in light of this, if we read it in context, other statutes that specifically authorize inferior officer appointments, the term official is not interpreted to mean that they get unlimited appointment authority. Congress is not hiding elephants in mouse holes, all right? You can't just tuck it in there and say, that's your power. Subsection D, as we continue, and they're laying out their case to Judge Chutkan. Trump's defense attorneys continue. They tell us the Nixon dictum, in the other case that Jack Smith relies on, is neither controlling nor persuasive in this context. In Nixon, the Supreme Court made only passing reference to the cited statutes in the appointment order. The Nixon court provided no analysis on this issue at all. Rather, as noted above, the court presupposed, well, I guess it's valid, for the appointment of the special counsel Archibald Cox to investigate Watergate. The language is dictum. They didn't do analysis on that, and so it's not persuasive authority. They just said, well, I guess he got appointed and he's prosecuting it, so I guess we'll just deal with it. The Nixon dictum states, under the authority, Congress has vested the Attorney General to appoint subordinate officers to assist him in his duties. That language appears to have been lifted verbatim from a conclusory assertion in the brief that was submitted by Cox's successor. That successor provided support for subordinate officers, which is disputed here. It did not establish that any of those statutes were authorized the appointment for an officer like Cox. That was not the argument that he was making in his brief. It's not the argument they relied on in that case. In fact, even in those arguments, Attorney General Richardson had only cited his authority under these provisions, which are not here. The Nixon case is dictum on these issues, so they were talking about other statutes and they're talking about here. And so the appointments in those cases are dicta upon dicta. Man, Nathan Wade and Fannie Willis were having a field day on this case. Dicta in the older cases cannot blind the courts to realities. The regulation at issue in Nixon was not ordinary and therefore distinguishable. Congress conditioned that confirmation as an independent prosecutor prosecutor with more involvement in the Senate without the president first consulting. And so consequently, Cox was intended by Congress and the DOJ, right, based on the development of this, with more authority. And the Nixon dictum concerned a peripheral subject that was not even raised in the case. And so the language is located in a section of the opinion, and the court's actual analysis was dicta. Based on these considerations, the single conclusory sentence in Nixon is non-binding and unpersuasive. Treating the sentence as dictum is consistent with this other case in the DC Circuit. In that case, the court characterized the dictum saying that the panel asserted the court had assumed without deciding that compensatory damages were available. And therefore, the same reasoning in that case applies here. The court is not bound by dictum. Now you know that, so don't apply it here. And moreover, let's be clear, Judge Chutkin, Jack Smith's appointment is also invalid for one independent reason. The appointment order also violates the Appointments Clause because Jack is a principal officer. Clarence Thomas said, if Smith is a principal officer, his appointment is invalid because the special counsel was not nominated by the president ever and was not confirmed by the Senate. And if he's a principal officer, he has to be, and he is a principal officer. The relevant factors in determining whether someone is a principal officer come from another case. We have to ask about the nature, the scope, and the duration of this officer's duties. And guess what? The special counsel regulations from Jack Smith afford Jack Smith the full power of a U.S. attorney. And what do we consider U.S. attorneys? Principal officers. The order says Jack Smith shall exercise the independent and investigatorial powers of a U.S. attorney. Garland himself has touted Smith's independence, and he explained that Jack Smith will not be subject to the day-to-day supervision of the department, meaning he's like almost as powerful as the DOJ, but not even a part of it. Prosecutors in this case later added that coordination with the Biden administration, which includes Garland as a department head and a cabinet officer, is non-existent. They don't even talk to him. These assertions are consistent with the special counsel regs and the principal officer status. So they say the special counsel shall determine whether and to what extent to inform the AG about their duties. Like, I'll tell you when I need to talk to you, Merrick, otherwise I'm on my own. Now, this framework does not lend itself to finding that Jack Smith is directed or supervised by Garland. No, he's as powerful as it gets. Justice Thomas cited this, and at oral arguments, Justice Kavanaugh described that case as one of the court's biggest mistakes. Oops. Justice Kagan has argued that the Morrison opinion is one of the greatest dissents ever written, and it gets better every year. Because Morrison addressed a different appointment under a different set of facts, it's distinguishable from that case, and there's no doubt that its now discredited analysis should not be extended any further. And so the appointment order that allowed Jack Smith to get here placed no real limitations on his tenure or jurisdiction at all, unless and until Smith is removed. The special counsel regulations largely defer to Jack on a decision about the conclusion of their so-called work. Nothing in the regulations, the appointment order, or the record more generally provides a concrete sunset provision for the cessation of his work. Regarding jurisdiction, Garland indicated that Smith could assume authority over investigation of, quote, any person or entity in connection with 2020, the president's handling of records under the Presidential Records Act, which covered immune conduct and decisions by Trump and numerous additional individuals dating back to at least 2018. So all years ago. All matters that arose or might arise from these enormously broad investigations and any matters within the scope of this subsection, which extended the scope to cover crimes committed in the course of and with the intent to interfere with the investigation. Now, so broad, right? The appointment order contains no geographic limitations, any state, anywhere, confers authority broader than that that's even given to U.S. attorneys who are limited to a circuit, to a region, to a district, who are principal officers, more power than them. Moreover, Smith's ability to refer to these discrete prosecutions, refer additional discrete prosecutions to U.S. attorneys, exponentially multiplied the scope of jurisdictional grant by him, right? So now he can manage other prosecutions. Now, collectively, these considerations demonstrate that Jack Smith is a principal officer, and because the appointment order does not comply with the default manner of appointment, his appointment violates the Appointments Clause, and the superseding indictment must be dismissed. Now, between November 2022 and March 2024, Jack Smith spent $20 million on his illegal prosecution of Trump. He has almost certainly spent many more untold millions between March 24 and today, right? How much more has he dumped as the election is escalating? A lot of money to drop those 1,800 pages. In addition to the $20 million spent directly by Smith and Jack's office before March 2024, other unspecified, quote, components of the Biden-Harris administration have spent more than $16 million on the same unlawful project. All of that money was spent illegally in a violation of the Appropriations Clause. The Appropriations Clause must identify a source of public funds and authorize the expenditure of those funds for the designated purposes appropriately. It is not mere happenstance that Congress is the chief guardian of the purse strings, except they're pathetic. Here's a quote. Drawing on the British experience, the framers placed the national government's fiscal powers in Congress's hands to check the propensity for aggrandizement and consequent loss of liberty endemic to a powerful executive branch that will create their own office and then fund it themselves indefinitely to do whatever they want forever. Since its inception, Jack and his office have unlawfully taken tens of millions of dollars from the government's coffers based on a permanent indefinite appropriation. These actions contradict the plain text of the relevant appropriation, and they're inconsistent with their representations to Congress when they argued that the Independent Counsel Act should be permitted to expire. At a committee hearing back then, Deputy AG Eric Holder explained that resource constraints are a needed check on prosecutorial overreach. Resource constraints. Cut off the money. Do you hear that, Congress? Even Eric Holder said it. To address this concern, the DOJ recommended letting the Independent Counsel Act expire, instead using lawyers appointed by the DOJ themselves. They said that, what safeguards would you have if the DOJ acts like maniacs? He said, well, expenditures, guys. You'll just limit our expenditures. Holder said, if you had special prosecutors who operated within that framework of the Justice Department, you would not have the kind of concerns that you have here. That would be part of the department budget. And so Congress did allow the statute to lapse. The DOJ issued the special counsel regulations soon thereafter, but the DOJ never delivered on the assurance that future special counsel would be subject to budgetary limitations. So now Smith is drawing on a 1987 appropriation that authorizes, quote, all necessary expenses and investigations and prosecutions by independent counsel, Jack is not that, appointed pursuant to provisions of U.S. Code. But 591 is a reference to the lapsed act. And so for the reasons above, there is no law. Jack was not appointed lawfully. And so there is no permanent appropriation for him to dip into, but he's been doing it for almost 2 years. That is an independent basis for his dismissal. He has no money. Everything that was done here was unlawfully funded, and so it also has to go. So furthermore, Smith is not independent in any sense contemplated by this. The independent counsels were appointed in conformity by law, the Independent Counsel Act, under the requirements of the Independent Counsel Law. Congress expected these types of special counsel would be completely independent of the DOJ, which is what that money was for. Now, Smith's failure to be independent under this appropriation is clear from a 2004 decision. That year, Jim Comey, gosh, these people are just in government forever, acting Attorney General, appointed then U.S. Attorney Patrick Fitzgerald as a special attorney. Comey exempted Fitzgerald from the special counsel regulations. During that year, the GAO, Government Accountability Office, evaluated Fitzgerald's access to the money, to the same money that Smith has abused. They explained, they said, no, you can't dip into that money. Even Comey said so. That is available for independent counsels. We looked. Was this special counsel independent? Department officials informed us that the express exclusion of Fitzgerald might conflict with the notion of independence. Now, the same cannot be said of Jack Smith, and this is a violation. This is improper expenditure, and now it's exceeding $20 million. The clause is about separation of powers. And here, what we need is an injunction. In addition to dismissing this indictment, the court should stop Jack Smith from spending additional public money in furtherance of the invalid appointment order. A court sitting in equity cannot ignore the judgment of Congress. Here, the legislation at issue, Judge Chutkin, is a 1987 permanent indefinite appropriation. Jack's office is spending money in violation of that appropriation. The prosecutor is breaking the law, stealing money. As explained above, drawing funds from the Treasury without authorization by statute. An injunction is necessary because a dismissal order will not necessarily stop this. In fact, you might dismiss the case and they'll just keep going. As illustrated by the fact, Judge Cannon already dismissed their case in Florida, and they're continuing to spend money on this case. She said, you're not a real boy, Jack, and you're stealing money. And he said, oh yeah? Well, how about I keep stealing this money and I just appeal you? What are you going to do about it? The office is directly pursuing the appeal. These actions are ultra vires. He shouldn't be allowed to appeal at all. Their money should be withdrawn now, funded from a source of money that they don't have access to. And so we need an injunction. Cut off the money because Congress won't do anything about it. And so for the foregoing reasons, Trump's defense team, in a beautiful motion, say, for the foregoing reasons, we have established constitutional violations and we call into question your jurisdiction, Chutkin. This court should grant leave to file this motion, and the superseding indictment should be dismissed with prejudice right now. The court should stop Jack Smith and Jack's office from spending any more money in furtherance of his illegal appointment and in violation of the Appropriations Clause, because Jack Smith is not a real boy and will never be a real boy and should never have been allowed to bring these cases this far, costing hundreds of millions of dollars in defense funds and billions of dollars in political damage, all instigated and ignited by our own corrupt government, our own corrupt Justice Department, to wage war against their political opponents using an illegal prosecutor, making up fake cases of insurrection, which they didn't even charge him with, and having raids of his residence in America. And so we know what Judge Chutkan is going to do here. She is not going to dismiss this case on this basis. She'll make it go up on appeal, and we're excited to see where it goes. So we're going to be here continuing to cover this case and more. Thanks for subscribing as we do.